Welcome, and you are listening to the Surety 3 General Agency Talk Radio with your host Rod Dawson, a general agent for Surety 3, an instructor at the Florida Bail Bond Academy, former officer and law enforcement instructor, security instructor, and director of the National Surety Association. We are here to talking about bail bonding and the bail surety industry here on this program. And here's your host Rod Dawson.
Hello, I would like to welcome you to the show and thank you for tuning in. Today, the subject is going to be on agents entering a third party residence, detention of a third party, searching a third party, and searching a third party automobile. We are going to review the powers and authority of a bail bond agent, exploring the legalities and illegalities of a bail bond agent as a functional figure inside the criminal justice system. Our job ensures that an individual who has been released on bail will return to each and every court appearance. We are ensuring the court, when we place that bond, that the defendant will return to court. Now, if the defendant does not honor his commitment, we have to honor our commitment by either paying the bond or having the defendant arrested or apprehended. That is our commitment. That is our promise to the criminal justice system. Well, I'm going to talk about this because I know a thing or two because I done a thing or two. In 2090, I came into the bail bond system as a runner or as a unlicensed agent. I got my runner's license after a year in 1991. In 1992, I became a licensed bail bond agent. And today, I am going to use the word bounty hunter because it makes everyone understand better than fugitive recovery agent or licensed surety agent. I'm going to use the word bounty hunter because that is the word that is in many of the opinions of the courts of appeal, and many of the courts use the word bounty hunter. But to us, we know that it's the fugitive recovery agent. Today, the stereotype of rogue bounty hunters remains, even though today you and I are licensed, most of us are trained professionals. But yet, we still have those rogue bounty hunters out there that's kicking in doors and taking names, as they want to call it. I feel as if we are still, I've never been in the Wild Wild West, but I watch so much of the TV shows and things, and I think that's where these rogue bounty hunters are getting their idea of what a bounty hunter is from TV. Let's talk about something that happened in 1997. Most of us will remember it because we was bail bondsmen at the time. 5 bounty hunters had broke into a home up in Phoenix, Arizona, and held several individuals by gunpoint. Y'all remember that? Eventually killed 2 young couple, and while a police investigation discovered that the men were not actually bounty hunters, hell, they weren't even bondsmen at the time of committing these here murders. But yet the public seeing them as rogue bounty hunters. And here they are, come to find out these guys was actually not even bounty hunters or bondsmen. They was disguising themselves as bounty hunters, which eventually fed into the public perception of bounty hunters as vigilantes. So, what I'm going to do here today is help the industry. Let's make our industry better. And let's talk about what authority bail bond agents has when entering or dealing with a third party or entering a third party residence or vehicle. Let's talk about that a moment. Let's talk about the constitutional rights of bail bondsmen. Yes, we have Teller versus Tainer that we can enter into principal home. We can break and enter. We can cross state lines. We can recover on the Sabbath. We can do all those wonderful things. And we have something that is known as apparent authority. And then we have express authority. And we have actual authority. Now, actual authority is what Teller versus Tainer give us, which is the authority in which we have by contract or by the U.S. Constitution. That is our actual authority. Then we have the apparent authority. Apparent authority is that of what the public reasonably believe that we possesses. Doesn't make it true, it's just that they believe it's true. And then we have the express authority. That authority is whatever authority, if you're a bounty hunter, whatever authority your subcontractors use from you as a bounty hunter. And if you are a surety who gave the bounty hunter the right to arrest, that is the express authority in which you gave to that bounty hunter, which is the same, the express authority in which your surety give to you in order to write and execute bonds. So we have express authority, apparent authority, and actual authority. Now, when we out there doing recovery, and this is only for those that really want to know and understand laws when they're dealing with recovery, by those imposters in 97 killing those couple, the state statutes and state courts have modified the bail bond and bounty hunting system, rendering it more amenable to the rule of law, where they put more restrictions on what we can and cannot do, and especially state where you're licensed to go into another state. Just for this podcast, I am going to call the untrained recovery agents or bounty hunters rogue agents, and only for the sense of terminology as well as definition, so we all are understanding the difference between a untrained rogue agent compared to a licensed and trained professional. And the only reason for this is that we in the bail bond system have been heavily criticized for operating outside the rule of law and engaging in excessive force and excessive violence towards a third party or the general public. So that's why I want to call it a rogue agent, an untrained agent. And mind you, this is for educational purpose only. This is not to criticize anyone in the field. And if I feel I need to criticize someone in the field, I have no problem calling your name out at all. Because if you're wrong, you're wrong. If you're untrained, you're untrained. It's just that simple. So I have no problem in calling you out. But I'm not going to do that. This is an educational training podcast. Okay, let's start off with our rights. Bail bond agents do have the right to enter and break in our principal home. A bail agent has the right to forcibly enter a principal residence, and that was first established in Teller, which held that we can break in a principal home, go across state lines, we can arrest them on the Sabbath. We have exclusive actual authority when it comes to tracking, locating, and apprehending a bail jumper, a fugitive that's on paper with a company in which you, remember that word, licensed or appointed to operate under. You must be appointed with that company in order to do recovery for that company or agency. Now, courts have decided that we do possess the right to enter a third party dwelling and legally arrest a bail jumper. We have that right, but in order to go in a third party house or dwelling, first we must have firsthand knowledge that that person is there. Firsthand knowledge is you or your intern that you have surveilling the house have actually seen the defendant with their own eyes. Or you got direct information from someone coming out that house that the person you're looking for is in that house, meaning a person that lived there or a person that was visiting there or a carpet cleaner or whatever it may be. Someone must tell you that's on scene at that time that that person is in the house. Not that they was driving a car yesterday and they were driving that car and you're assuming they're in that house today. That is not firsthand knowledge. We're searching for a bond skip. We, the bail bond agent, are frequently confronted with the prospect of entering a third party resident or home. But common law, prior court decisions, and statutes help the court to determine that a bail bond agent actions. Let's take a look at Her versus State, 1999, for example. The defendant, Frederick Her versus State, 1999. Her was a licensed bail bond agent, and he was convicted of fourth-degree burglary for forcefully entering a dwelling of a third party in search of a bond skip. When he and his partner discovered that the dwelling was owned by someone else other than their suspect, they apologized. Her was later arrested for burglary. Okay, they found out they went to the wrong place, they apologized, and they went to the right place. Okay, Her appealed his conviction, maintaining that a reasonable belief that the intrusion was warranted is a complete defense to fourth-degree burglary. However, the court rejecting her argument and held that even if Her had believed that he was entitled to enter the home of the third party, the defense will not exonerate him for burglary. The court also opined that Her did not have a reasonable basis for concluding that the bail skip was in the residence, since he failed to substantiate the authenticity of the tip he had received. In other words, Her did not do his homework. The court says you must do your homework before entering a third-party residence, meaning setting up surveillance, checking other neighbors, or whatever you can do to authenticate that that person is there. The court affirming the burglary conviction of Her, the court concluded that the bail agent should have conducted surveillance on the property and checked with the neighbors to see if anyone recognized the suspect living there. So like I said, you have to have someone to verify your tip. You just can't go off, well, I received a call, this person was here, and I entered. No, it don't work that way. Now, let's deal with another case here. In the appellate courts, State versus Tapia, 1991, Mishler versus State, 1996, State versus Portnoy, 1986, the appellate court ruled that neither common law nor statutory authority allow a bail bondsman to forcibly enter a third-party residence. Terry Woods was employed as a bounty hunter for a bonding company. That would be Woods versus State, 1999, was found guilty of second-degree assault and first-degree trespassing. Wood attempted to locate a bond skip named William Hernandez. Upon entering the residence, Woods encountered a resident, Martin Thorne. Thorne claimed that he did not know Hernandez and that Hernandez did not reside at the residence. After hearing voices from the front of the house, Wood kicked down the door. On appeal, Woods first claimed that he could not be convicted of the first-degree trespassing because insufficient evidence was presented to show he knowingly entered unlawfully into Thorne House. As a bounty hunter, Woods possesses a bail ID card that authorized him, when apprehending a bond skip, to break into the home of a bail skip for the purpose of apprehending. Rejecting Woods' argument, the Court of Appeals upheld the conviction because he had insufficient evidence to establish that Hernandez was in the house. The court also ruled that Woods' reliance on his bail ID card was unreasonable basis for his knowledge that Thorne, not Hernandez, resided there. This reminds me of something that happened in Jacksonville, Florida. I get a call from an attorney and his client was on the phone and they asked me about the authority of bail agents entering into a third party residence. I recited Woods as well as the other previous ones I just mentioned. This same incident that happened in Woods' case happened to this young lady. A police report was filed that two bail bondsmen came to her rental property, kicked in the door, and brandished firearms in her face. She called the police and filed a police report. The bondsmen were very rude. I'm going to call them road agents. They were very rude, and she stated the skinny one was more, I guess, pleasant to deal with than the more heavier one with the beard. And I have no idea who the agents was, but later I was informed who they were. But I'm not that type of person that I'm here to teach. I'm here to let you know what the laws are. If you kick in someone's door without knowing for a fact, and it's a third party, it's not the resident door, my greatest advice to you is not to do it. But my best advice, if you do it, and whatever you do, don't point a firearm at an unarmed third party. And please fix the door and apologize with many thousands of apologies and hope for the best. Let's examine a post-conviction relief application of Philip McFarland. McFarland versus State, 2003. McFarland was a bounty hunter who was found guilty in trial of assault and second-degree burglary. McFarland and his partner were pursuing a bail jumper, Gonzalez. McFarland received a tip that Gonzalez was hiding in a mobile home. Consequently, he broke down the door and entered the wrong mobile home occupied by the Leach family, an innocent third party. After realizing he made a mistake, McFarland apologized. I like that. He apologized and went to the trailer park next door and he arrested Gonzalez. But on appeal, the Court of Appeals affirmed the conviction of assault and second-degree burglary related to the Leach. Well, what McFarland did, he decided when filing his post-conviction relief application, claiming that he had extra legal authority to enter a third-party resident based on common law established in Taylor. I doubt that very seriously. Tell me why. Someone out there tell me why. What does Taylor says? We can break and enter who residence? Correct. We can break into the principal residence. The Court of Appeal rejected his argument, reasoning that Leach family was completely innocent. In Taylor, the U.S. Supreme Court held that the bail bond agents can enter the principal residence, not referencing a third-party dwelling. True or false? Hell, we know it's true because it's McFarland versus State, 2003. Look it up. Carr versus State, 2001. William Carr received a tip that his fugitive was in a black Cadillac driving east on I-10. William was a bounty hunter, spotted the car. He followed the car until they got off I-10 into a convenience store. William blocked the car in. Him and his partner got out, went to the passenger seat, and removed the defendant. William ordered everyone in the car to stay in the car, do not move, and keep their hands where he can see them. William was convicted of 3 counts of false imprisonment. Why do you think that happened? Because William has no control over the occupants of that car. They are third-party individuals. They have nothing to do with your fugitive other than the fact they're all in the same car together. You cannot give them directives. Video was sent to me the other day. I took a look at the video and he asked me, what did I think? I'm like, well, the agents, from what I see, a black truck pulled in front of a car that was at the gas pump. And the agent pulled a defendant from the back of the car sitting behind the passenger seat. Once they got the guy out the car, I heard someone state, I dare y'all two to try me. I'm gonna pat you down and don't you freaking move. Then I heard everybody out of the car. You right there, put your hands on the car and do not move. They was talking to third party that was in the car, passengers. The defendant name was Chris Burgett. From the video, I seen all three third parties that had nothing to do with the paper or the bond, hands on top of the hood of a car and being searched by the agents. I seen the car being searched by the agents. On the next video, I see two agents somewhere down south went to pick up a gentleman. A big guy was in the doorway. They asked the gentleman, they gave him commands to step out. He wasn't fast enough to step out. And next thing I know, the ASMIT came out, which is a expendable baton, a club, and it's made out of metal with a metal ball at the end. And they just went to wailing on this guy. I mean, they went to beating on him, and the other agents throwing punches. The guy was a big guy, really fat guy. He really couldn't move that well. And they just pounded on this guy. Got him on the ground, chokehold, and I mean, they just pounding on this guy. So the lady come out, the house, what are you doing? Man, the guy take the same ASMIT and go busting her windows. I'm like, what the freak is happening here? These are rogue agents. These are not trained agents. These are rogue agents. This is what give us a bad name in this industry. The next video, I really can't comment on what happened previously to them forcefully entering the dwelling because it was not available to me when he sent it to me. But all I heard is, are you ready? Okay, we're kicking it in. Let's go. They entered. The house was somewhere in Quincy, Florida. They are looking for a gentleman by the name of Tyrone Wimberly, and he got, it doesn't matter how many warrants. He can have 900 of them. It really doesn't make a difference. Come to find out, that is not Tyrone residence. That is the residence of this young lady. When she came out, they giving the occupants of the house commands and telling them to get out of their own house, giving them directives. And the young lady said, it's only me and my son is in here. How did you guys get in here anyway? And come to find out, the Quincy Police Department is with them as well, a color of authority. We'll get into that later. Well, they find the gentleman in the back somewhere, and they giving him directives, giving him commands to get on the ground, get on the ground, get on the ground, I'm gonna tase you. I heard another agent say, tase him. Tase him down. And next thing you heard was pop and well, the sound of a taser. So they tase a man that actually was following their directives. He was actually complying to what the commands were. I guess he wasn't moving fast enough. So there's nowhere in statutes or opinions that allow us to forcefully enter a third-party resident without actually doing our own surveillance or getting firsthand knowledge from someone that's actually in there before we forcefully enter a dwelling. We cannot stop a vehicle and block them in from movement. When you block someone in with your person or vehicle, and you do not allow them to leave, that's false imprisonment. If they cannot leave and they cannot move, or you told them by command not to move and place your hands on the car, you've just committed a crime. We have no authority, express, actual, apparent. We have no type of authority on a third party. We cannot see a third party walking down the street and they look like a defendant and we demand them to stop and check their ID. Hell, police officer can't do that. What I am saying here, instead of being a rogue agent, instead of being an untrained agent, why don't you be a trained, licensed professional? Why don't you get with someone that knows and understands bail bond laws, that knows and understands what you can and cannot do in this business? And I'm not talking about a police officer that retired and came into the business and been in the business 1 or 2 years. He don't know nothing about bail bonding. He know as much as you know about bail bonding. He know as much as you know about recovery, because it tells me for the Quincy police officers to be with these bondsmen, to kick in a third-party door, that tells me right there, and that should tell you, and which it does. A police officer, first thing they tell you when they come on the scene, they know we have rights to do things, but they don't actually know what the rights are. So we get away with a lot of stuff because the police officers don't know what we can and cannot do, but the court sure as hell does. And you're going to come and find smart lawyers out here that don't mind giving a paralegal a task to find these court cases. You're going to find this and you're going to have problems. So why have problems when you can do the right thing in the beginning? Okay, in closing, listen and listen closely. If you do not have the training, don't do it. Stay away from recovery because right now we are under attack and you are making it worse. We need to get these rogue agents away from recovery until they have training in recovery. If you do not have a military or law enforcement background, meaning that you have experience not hunting man, but experience firearms and defensive techniques as well as professionalism, please don't get into recovery at this moment until you get that training. I also want to say that we are here to help. We are not here to call the department when we see something wrong or get people in trouble. Let's change our image within. Let's help one another first. If that doesn't work, then we'll go to plan B. Let's help each other first. Let's try something new. If the old stuff did not work, how Martin said, run, tell this. If that didn't work, let's try something new. Let's help one another. Let's be there for one another. As they said, we have a common enemy, and that common enemy is the pretrial services that does not use us for release. So let's get the training that we need and leave all this other stuff behind. There's a lot I want to say on this topic, but I do not want to, I have to stay neutral in this. I want to thank everyone for tuning in, and let's be safe out there, and let's write good bonds.